The trends are not good if you're worried about punitive damages, right? So the frequency of the award has gone from about 2% of all personal injury cases to right around 5%. And that's over the last couple of years. And then there's gradations of that.
Welcome to the Willis Towers Watson podcast, Vital Signs, Risk and Insurance for Healthcare, where we discuss the risk management and insurance trends and issues facing the U.S. healthcare industry. We'll speak with our industry experts and clients in search of ways to improve your risk and insurance vital signs.
Welcome, everyone, to Willis Towers Watson's podcast, Vital Signs, Risk and Insurance for Healthcare. Today's podcast represents episode 5 of our first podcast series. In this series, we are looking at HPL coverage issues in a hard market, and today we're going to be discussing coverage for punitive damages. My name is Mary Ann McGivney, and I head up Willis Towers Watson's healthcare industry practice. My guest today is Will Eustace. Will is our Casualty Coverage Officer here at Willis Towers Watson. Thanks for joining us, Will.
Thank you, Mary Ann.
Well, we're glad to have you. I'm sure that as our coverage guru, you receive a lot of questions on various policy terms, but punitive damages must be a topic that comes up often, as it's not limited to HPL, but can impact all types of casualty coverages. So I'm guessing you hear this a lot.
Quite a bit.
Before we get into the details around actually insuring punitives, perhaps we should review some of the basics. Why are punitive damages awarded by a court?
So, Mary Ann, the court is trying to do a couple of things. Courts want actors to behave responsibly in society. And when somebody goes so far off the beaten path that punitive damages should be considered, they want to either punish the wrongdoer or deter similar conduct by others so that it doesn't happen again. And then you could also say occasionally it's to enhance compensation when a court feels as though compensatory damages just aren't enough for whatever happened to the plaintiff.
Okay, well, that makes sense. But are there different types of punitive damages, or are they all the same?
There's a couple of different types, really. Basically, you can divide it up between direct and vicarious. Directly assessed punitive damages are when an actor does something that's wrongful on their own part, they're directly assessed against that person. Vicariously assessed, on the other hand, are when an insured is liable for the acts of another. So a good example there would be employer liable for the acts of an employee when the employee was acting in the course and scope of employment. Those would be vicariously assessed against the employer.
Sure, and we see that in malpractice too, that exposure to vicarious liability, so that's familiar. What are courts and juries looking for when they determine whether punitive damages should be imposed or not?
Sure, so we're obviously looking for wrongful conduct of some sort. Now that could be willful, and a willfully harmful act is obviously going to draw punitive damages, but it doesn't necessarily have to be that. It could be malicious. It could be what courts call wanton behavior or reckless behavior. There's no fine line there where you go from ordinary negligence to gross negligence to wanton, but you can conceive of it as just moving along a continuum where the actions are getting increasingly worse. And the courts are really looking who breached a duty of care. And then some relationships, teacher-pupil, doctor-patient, bring an enhanced duty of care because of the relationship of the parties.
Sure, and you have vulnerable populations with patients, so that makes sense.
Right.
Okay, so that covers the basics, but let's talk about the insurance. And the million-dollar question is always, can you insure punitive damages? Are they insurable?
And this is where I give you my most definitive answer. It depends. And it depends because insurance is a creature of state law. So each of our 50 states can handle issues differently in the so-called laboratory of democracy. So if the state allows insurance of punitive damages, then it is. And if the state doesn't, then it isn't. So I'll tell you about half of the states outright ban insurability of punitive damages. Many of those will allow it for vicarious liability because the actor who's being insured is not the literal at-fault actor and they're just being charged with it. The courts that ban insurance for punitive damages, they're really saying you're violating public policy by doing this. Why? You're transferring the burden of somebody's horrible conduct to innocent premium paying insurers, the other insurers who pay their premium. And you're undercutting the deterrent effect that we talked about earlier, where you're trying to deter other actors from acting in a similar fashion. Well, if you're going to allow it to be insured, you've taken that off the table. And
Right.
then occasionally courts say, this is kind of a minority view, that punitive damages awards are windfalls for the plaintiff. You get hurt in an accident, you get X dollars compensatory damages. I get hurt and I get X plus punitive. Why should that be? Both parties were hurt. That kind of theory.
Right.
So that's really what you see.
Okay. Claim severity is something that we discuss a lot with our clients, particularly over the last 12 months, primarily because it's been increasing and it's been ugly. What are we seeing from the courts regarding punitives? What are the trends there?
The trends are not good if you're worried about punitive damages, right? So the frequency of the award has gone from about 2% of all personal injury cases to right around 5%. And that's over the last couple of years. And then there's gradations of that. If a plaintiff seeks punitive damages and prevails at trial, about 35% of the time, punitive damages are going to be awarded. So a little over a third. Now you take the punitive damages up from a range between 1 and 10 million. And now you see punitive damage awards at about 53% of the time, half the time.
Wow.
Greater than 10 million, and your chance of a punitive verdict goes to about 82%, which is pretty significant, especially if you're a manufacturer out there with product or with patients in the industry we're talking about. So
Yeah.
it's kind of important. Now everything has to be with a grain of salt, right? So only about 2% of cases filed go to trial. That means a lot of things get settled. When you settle a case, you obviously don't stipulate to punitive damages. So we don't know about that. Even when the case goes to a trial and there's a verdict rendered, a lot of those cases are settled on appeal. If you've ever been to an appellate court conference, which I have, the court is mightily focused on trying to bring the parties together for a settlement. So it's growing, and there's some folks that feel that this jury pool that we see today is a little different than the past, and these kind of figures would bear that out.
Sure. And combined with the concern that severity's been on the rise, with when punitives are assessed more often on larger cases, it does seem like we might see more punitive damages going forward than maybe we have in the past.
I think you will. I think that's what the trend line is definitely showing, and it could also take place in the healthcare industry, which is something we focus on.
Yeah, so let's bring it home to healthcare. What would prompt a punitive verdict for this industry?
Well, so I said before, right? So if your healthcare provider acted in an intentionally harmful manner, and you don't really see a lot of that, but if that happened, that would prompt a punitive verdict. More what you see is a gross violation, alleged as a gross violation of standard of care, behaving indifferently toward a patient, and this is where records would come in. Person hit the call button 25 times in a row and nobody responded to them, right? I'm I'm,
Right.
I'm making that example up, but you see where that goes. If there's reckless or grossly negligent conduct toward a patient that it's deemed to violate the professional standard of care in that area, then you got a chance at a punitive verdict. And you even alluded to earlier, special relationships, teacher pupil, doctor patient, right? And
Yeah.
people are looking for a higher standard of care from a medically trained professional. And so they bring that with them when they go back in the jury room.
Right. Yeah, and we spend a lot of time talking about standard of care in malpractice claims as well, so we're really familiar with those conversations. But how does a healthcare provider go about protecting themselves from punitive damages? What can they do to insure themselves?
Right. So they have the options that any other insured has, and there are really about four of them, right? One would be affirmative coverage, where the practitioner's combined CGL professional affirmatively states that it covers punitive damages.
That's an interesting one. And I think it's an important distinction to make because you're talking about true affirmative coverage, but wouldn't silence in a form work just as well?
A lot of insureds think silence is golden, if you will. And
Yeah.
it's not necessarily so. Remember, we talked about public policy before on why states won't allow punitive damages to be insured. So many states, when the form says damages, they read in, well, that must mean compensatory. Obviously, we wouldn't insure punitive, right? And then there are two states that literally require affirmative punitive coverage. Those two states are Hawaii and Utah from memory. And they say if your policy doesn't say we cover punitive damages, it doesn't cover punitive damages. So silence, ultimately silence isn't really golden here. You want to be
Right.
careful.
Yeah, sure. Okay, so you mentioned four options for a provider to protect themselves. Affirmative is one of them.
Right? There's something called a punitive wrap policy. And this
Okay.
wrap policy literally is designed to wrap around an onshore domestic insurer, a U.S. insurer, if the jurisdiction which is going to govern that policy, which is a contract, prohibits insurance of punitive damage by law or by statute or public policy. Public policy, a lot of states do. Some states also do it by statute. For good examples, California, into the code book says you cannot insure punitive damages. So you buy the wrap policy offshore, and it literally indemnifies the insured for the punitive damages that the insured pays. A lot of carriers offer something. It's got two names that are related, MFV or MFJ endorsement. And this goes on your domestic policy. Most favorable venue or most favorable jurisdiction, they really mean the same thing. And it gives you a list of states, generally states of the insurer, states of the insured, where the insured's doing business, state where the policy was bound, state where the punitive damage was awarded, that kind of thing. And it gives you a selection, almost a menu of states, which if any one of these states covers punitive damages, carrier agrees that they'll go by that provision. Downside there is that we don't have any cases on that. So I wouldn't be able to tell anybody. It's not the same as sleep insurance, like a punitive wrap, the offshore policy, because we just don't have decisions on it. The last and final would be a policy form which insures compensatory and punitive damages. A good example of that would be what we in the industry call the IO form, the integrated occurrence form. And that's sold in Bermuda and sometimes in London. And it literally says damages include compensatory damages and punitive damages. And so it's really a variant of the affirmative coverage of the form.
Okay. Well, that's helpful, but can we talk just a little bit further on punitive wrap policies and how they operate?
Sure. So you buy the wrap. It's varies, but ballpark 10% additional premium for the wrap policy. That premium doesn't give you additional limits. The limits of the wrap form match the limits of the onshore. If the onshore is 10, the wrap is 10. And whatever is paid erodes both limits. So nobody should ever think it's an additional set of limits. It's just that the coverage is literally wrapped and triggered when the domestic policy pays the compensatory damages but cannot pay the punitive aspect because of the statutory or the legal prohibition or the public policy we talked about earlier. The wrap is governed by New York law, but it specifically states, except with respect to New York's prohibition on the insurability of punitive damages, which wouldn't make the wrap very good if it didn't say that, because New York forbids that, as do many states. But the wrap is the kind of thing, it gives the client, you heard me say sleep insurance before, it really is sleep insurance. Then you don't have to worry about fighting the plaintiff on one front and having a fight with your carrier on the other front about just what this case is worth when the plaintiff is demanding punitive damages in a bad jurisdiction and it's a bad case, right? That's what we always try to keep our clients out of those situations. And that's why we really call it sleep insurance.
Sure. What else should our listeners know about how a wrap operates? Anything else in there that you think is important?
Sure. So for those not familiar with it, the dispute resolution is not the typical US litigation. It's an arbitration, which is usually conducted in Bermuda or London, could be Canada, could be somewhere else. The salient point there is cannot be in the United States because the Offshore Bermuda carriers are not subject to United States law. Payments by the RAP. The payment is an indemnification, so the onshore carrier pays, the insured pays the punitive portion of the verdict, and then demonstrates to the carrier that that has been paid, and the RAP carrier reimburses the insured. That payment for reimbursement is made in Bermuda, can be picked up by the policyholder's Bermuda broker, but it has to be made in Bermuda because, again, they don't come onshore. And then the best thing you can ever do in coverage is give notice early and often. And you need to give, if you're the policyholder, you want to give separate notice of claim to that Bermuda carrier issuing the RAP policy so you don't get any jam that way.
Yeah, that's a really good point, because I could see where somebody might think that they've reported the claim and they might not think of the punitive piece and needing to report that separately.
Yeah. Late notice has killed 90% of good coverage cases. So
Yeah. So we did talk a little bit about the integrated occurrence form. Anything more we should touch on there?
it's a form that has a high retention, typically starting about 25 million. It's a good form for those who might face a series of losses that are not necessarily break the bank, but added up together, sort of the death of 1,000 cuts, if you will. An integrated occurrence form can stop the bleeding at 25 and above. It includes, literally says flat out, that damages include punitive damages, which is a wonderful thing. There are some domestic insurers occasionally will put a choice of law provision in for certain things. You see it a lot for pollution endorsements. Doesn't happen a lot. And then there's other carriers, they won't do an offshore RAP, but they affirmatively provide punitive damage coverage by calling out punitive damage friendly jurisdiction like New Hampshire.
Mm-hmm.
And that's, that does the trick, because then you don't have to worry about having to fight onshore.
Okay. And you mentioned the MFV or MFJ endorsement. Is there some more to talk about there?
Yeah, it's most favorable venue. It has a lot of facial appeal, right? All you need is the law of one of these states to apply and you're good. But there are a lot of nuances in coverage litigation, which I'm not going to bore your audience with, but generally speaking, there's not usually one issue at play. Remember, we talked about notice and late notice, and there can be a lot of other issues with insurance for the case itself that you might not necessarily be able, if you're the coverage counsel for one of our insureds, to put that litigation in one of the states that is pro insurance for punitive damages. So that's something we have to think about. The wording varies by carrier. They all kind of look to a substantial relationship test, the insurer's home state, the insured's home state, that kind of thing.
Mm-hmm.
But not all are created equal, because some have additional exclusions and that sort of thing. So you got to read those closely and sort of walk it through in terms of what your likely exposures are. And again, we said, is it enforceable? Well, going to have a tough time in states like New York, Pennsylvania, California, we mentioned, and a bunch of others. About half the states you might have a problem. So enforceability, unclear, particularly when you give the overlay of the multiple coverage issues at stake in your typical coverage litigation. They're a benefit, but because they don't come with an additional premium, insurers should think about them that way when they're considering buying an offshore RAP.
Yeah, that's a lot to think about. And despite the eye-catching headlines that usually go along with punitive damage cases, so far they haven't been very frequent, although it sounds like they're increasing in frequency. But I think that makes it hard for people to remember all of these nuances when they're considering how to cover them or what to do when a claim comes up. But that's why I'm really glad we have you, Will, to help us when the questions arise. So thank you so much for your participation today.
Oh, anytime, Marianne. Good talking to you, as always.
You too. I'd also like to thank our audience and those that tuned in to join our discussion. As I mentioned earlier, this is the 5th and final podcast in our inaugural podcast series. We hope that you enjoyed this series and will join us again in a future series of Vital Signs, Risk and Insurance for Healthcare.
Willis Towers Watson hopes you found the general information provided in this publication informative and helpful. The information contained herein is not intended to constitute legal or other professional advice and should not be relied upon in lieu of consultation with your own legal advisors. In the event you would like more information regarding your insurance coverage, please do not hesitate to reach out to us. In North America, Willis Towers Watson offers insurance products through licensed subsidiaries of Willis North America Incorporated, including Willis Towers Watson Northeast Incorporated in the United States and Willis Canada Incorporated. Thank you for joining us for this Willis Towers Watson podcast featuring the latest thinking on the intersection of people, capital, and risk. For more information, visit the Insights section of willistowerswatson.com.